How would you like to make a partner right now?
Oh no. Oh no! Ooh, quid pro quo sexual harassment! Oh, is that even consensual? Hey, Legal Eagles, D. James Stone here, teaching you how to think like a lawyer. Today we are covering one of the funniest legal movies of all time, Liar Liar. This is the first in a two-part series. As always, remember to like and subscribe, and be sure to comment in the form of an objection. I'll either sustain or overrule your objections. And while you're there, let me know what movie or TV show I should do next. And stick around until the end of the video, where I give the first half of Liar Liar a grade for legal realism. So, without further ado, let's dig into the first half of Liar Liar.
My dad, he's a liar.
A liar? Oh, I'm sure you don't mean a liar.
Well, he wears a suit and goes to court and talks to the judge.
Oh, I see. You mean he's a lawyer.
I object. That is slanderous, and I will take that little boy to court and sue him for all that he is worth. Or not. It's not defamation. I'm just kidding.
Reed, do you have a moment?
I'm sorry, I'm very late. It's my day to be with my son.
A couple of reporters want to talk to you about your big win today.
Oh, yeah? How's my hair?
Fabulous. You look great.
So lawyers often have to talk to the press. I've talked to journalists on many occasions to talk about recent developments in the law and things that are going on in my cases, because if you don't do PR for your client, no one will, or worse yet, they'll talk to your opponent who will give a completely different spin, and you've got to get ahead of that to make sure that your side gets out.
Fred, it's your duty to present the strongest case possible.
The strongest case possible, consistent with the truth.
Will you let the judge
Yeah,
decide
sort
what's
of.
true? That's what he gets paid for. You get paid to win.
So lawyers are bound by the rules of professional responsibility and ethics for their particular jurisdiction. And most jurisdictions base their rules on the ABA model rules of conduct. And under those rules, a lawyer has an obligation of candor to judges and juries. In other words, they have to be honest to those judges that they're up in front of. So under the rules of professional responsibility, no single lawyer can lie to a tribunal. And in fact, if the lawyer knows that their client is going to lie to a judge or jury, that lawyer has an obligation to not elicit that information. In fact, the lawyer has a duty to try to convince their client not to offer false testimony in front of a tribunal. So there are plenty of rules of professional responsibility that prevent lawyers from actively lying to a court. So under Rule 3.3 of the Model Rules of Professional Conduct, a lawyer cannot lie to a judge. A lawyer cannot knowingly elicit false testimony from their client. And in fact, if you know that there is contrary legal authority out there, you have to give that to the judge in addition to the legal authority that actually helps your case. So this attorney is absolutely right that there is a limit to the kind of representation that you can use for a particular client, and you can't actively lie to a judge or jury to help your client out, regardless of what your client wants.
Damn it!
I completely forgot.
Oh, what a surprise.
You are a saint. I should buy you a gift.
You did.
I always do the classy thing.
I think it's inappropriate for a lawyer to rely on his legal secretary or legal assistant to get gifts for his family. However, I will put in a plug for having a good legal secretary. They can really save your life when you are working really long hours or you have a filing that is on a tight deadline. They can really be the difference between life or death in an attorney's office, because they know your schedule, they know what's going on, they know what needs to be done, and often they're knowledgeable enough to really help you out when you're in a tight bind.
Any calls?
Judge Rawlings' clerk, he needs your filing.
Tell him it's in the mail.
Right, she'll do it next week. Mr. McKinley.
Oh,
you
man.
confirm your meeting tomorrow.
All right, so One of the things that drives all attorneys just completely insane is the deadlines that they have to adhere to. When a court or a judge sets a deadline, the worst thing you can possibly do is let that deadline lapse, because the courts have a very busy schedule and you're at their mercy. So if you miss a court-set deadline, you can be in a huge amount of trouble. You could miss one deadline and that could be grounds for getting disbarred or getting sanctioned by the court and really prejudicing your client. Often these deadlines are what's called jurisdictional, which means that if you miss that deadline, your case might get dismissed. So deadlines are this malpractice trap for attorneys, and I've seen many, many appeals taken where the attorney just screwed up. They missed a deadline, they were late in a filing, and you cannot do what Fletcher Reed is trying to do here and just push off a deadline when the court is calling you up and saying you need to file something. That could be really important to the case, and you could get horribly sanctioned if you fail to adhere to that deadline. So that's the first time Fletcher may have been disbarred in this particular movie.
I heard about your victory. Congratulations. You know, you're making quite an impression on the partnership committee.
Oh, that's right. You folks are meeting again soon. I've just been keeping myself so busy, I haven't even thought about it.
Most law firms have a partnership committee that is formed by a group of equity partners, which means that they are actual partners. They own equity in the particular law firm, and they're going to choose who gets to come in as another equity partner for that law firm. One of the things that most people don't know about partners in a big law firm is that in order to become a partner, you have to actually invest, usually, you have to invest in the firm itself. So often when you're being upgraded from an associate to a partner in the law firm, you actually have to make a substantial contribution, often on the order of hundreds of thousands of dollars, to purchase your equity. So they are voting to let you in to allow you to pay the firm to allow you to be a partner in that law firm. Hopefully, if you're paying a substantial amount to become an equity partner in a law firm, it's profitable enough that you will recoup your investment and then some. Another thing that a lot of people don't know about partners in the law firm is that they often don't get paid a salary. They only get paid a percentage of revenue or profit in the law firm itself. So often when you go from an associate in a law firm to a partner, you forego a salary and you only get paid maybe once a year based on the general financials of that entire firm. So there's a lot of good and a lot of bad associated with being a partner. But obviously Fletcher here wants to become a partner, as most people do in a law firm.
Well, this is good. This is really smart.
Thank you.
Only, well, it's not true. I mean, does that present a problem?
So if the lawyer himself can't lie to a judge or jury, I really doubt you can convince your client to lie on his or her behalf to the judge or jury. So I think this is a violation already of Rule 3.3, the duty of candor.
You're the victim here. The wife of a cold, distant workaholic, starved for affection, driven into the arms of another man.
7.
Yeah, whatever. You're not trying to deny him what is rightfully his. All you're insisting on is what is rightfully yours.
Yeah.
And maybe a fraction more. I think you're bending over backwards.
So ironically, despite them saying that whatever was in that legal brief that was a lie, the argument that Fletcher Reed is making here aren't really lies, they're just creative ways of talking about the facts as they exist. So his rhetorical flourishes here talking about how she's the victim, those can be true from her point of view. So it's not necessarily a lie in and of itself, it's just a creative argument that uses the facts as they exist. I don't know if that would win the day against a prenuptial argument that's pretty cut and dry, but so far what he's talking about probably doesn't breach Rule 3.3 yet. Well, we'll see.
You're right, Mr. Reed. I am tired of getting kicked around.
Good for you!
Thank you. I am so grateful I have an attorney I can trust.
Oh, God. All right, so let's talk about whether it's appropriate for a lawyer to engage in sexual activity with his or her client. Up until last year, California was one of the few states that said that a lawyer could, in fact, engage in sexual relations with his or her client, so long as that attorney didn't coerce or force that client into that activity under duress. That rule changed last year when California Supreme Court brought California into line with most other states that says an attorney cannot, under any circumstances, have sexual relations with their client unless that relationship existed before the attorney-client relationship existed. So, at the time that this movie was made, it was sort of okay for clients and attorneys to have a romantic relationship. Now, that's not appropriate at all. So that's something that Fletcher really needs to watch out for. He needs to be careful with that client.
Oh, you are good. You are very, very good. You know, the cold case is worth a truckload of money to this firm. If you win, I guarantee you'll make partner.
Oh.
In fact, how would you like to make a partner right now?
Oh no. Oh no.
Oh, I mean, I should.
Ooh, quid pro quo sexual harassment. Oh, is that even consensual? Really, I think that could be considered quid pro quo sexual harassment. She is making it seem like his partnership is contingent on some sort of sexual relationship with her. So this is yet another example of quid pro quo sexual harassment showing up in Hollywood. Mixing romance and an employment relationship is always tricky. A jury could look at this situation and say that his promotion is premised on this romantic relationship with her, and thus it's a quid pro quo. Always tricky, never a good idea.
You know, the cold case is worth a truckload of money to this firm. If you win, I guarantee you'll make partner.
Oh.
I don't think she can make that guarantee. A partnership committee is just that. It's a committee of other partners. And if Fletcher doesn't have the right numbers or the right personality or there are other problems, then there are all kinds of reasons why he would not be able to make partner, even if one particular partner really goes to bat for him. In fact, while it is really helpful to have at least one partner go to bat, you need to really wine and dine the whole partnership committee in order to make partner. All right, so fun fact about going to counsel table in a courtroom like that. Normally you wouldn't be able to walk right up to counsel table because there are a lot of different cases that are going to be called before the judge that day, and you may not be the first one. But if you ever go to a courthouse, if you look outside the door to the courtroom, then you'll see what's called the docket. And the docket will explain what cases are up for a hearing that day, and there will probably be a dozen of them at least, and you'll find which number you are on the docket, and odds are they'll go sequentially down and leave the most contentious for the last one so that they get the most time. So if Fletcher has the first number on the docket that day, often you will go and you'll just sit down straight at counsel table. But before you do that, you have to check in with the court clerk, and in California, generally you give them 2 copies of a business card so that they can attach that to the sheet that talks about what your case is there for. Once you check in with the court clerk, then you can sit down if you are the first number to be called on the docket.
Fletcher.
Dana!
All right, Samantha. How much will it take to put an end to all this?
50% of your estate.
50%? With a prenup and proof of adultery? What's your case?
Our case is simply this.
It is pretty normal for attorneys in the same field to have a prior relationship, to know people by their first name, and to talk with them. What's odd here, though, is that Fletcher started out this movie representing a criminal defendant, or presumably someone who was a criminal defendant, and has now jumped into divorce law, which you don't really see very often. So it would also be weird for him to have this prior relationship with another divorce attorney when it's not clear that he's ever represented someone in a marital dispute like this.
All rise for the Honorable Judge Marshall Stevens.
Honorable.
Good morning. Call case number BD 09395, Samantha Cole versus Richard Cole. How are we doing this morning, Counsel?
Fine, thank you.
And you, Mr. Reed?
I'm a little upset about a bad sexual episode I had last night.
So far, this is exactly what happens when the judge comes into the courtroom and calls the hearing to order. They'll read the case name and the case number so that the stenographer can take that down and make it part of the official record so that they have a record of what's going on. And he'll make a little bit of small talk with opposing attorneys before getting the ball started and proceeding into the hearing.
First, Mr. Reed, I see where your client...
Your Honor, I would like a continuance!
This case has already been delayed several times, Mr. Reed.
I realize that, Your Honor, but I would really like a continuance!
I'll have to hear good cause, Counsel.
I can't lie!
Commendable, Mr. Reed, but I'm still waiting to hear good cause. Now, do you have one or not?
Not!
Motion for continuance denied. Is there any chance of a settlement in this case?
Yeah, so that is right on. Attorneys can ask for continuances all the time, and often, especially in California state court, things are going to be delayed over and over and over again. So if you get to the point where the case is ready to go to trial, then the judge is going to want it to go forward with due speed. So you can get a continuance, but as the judge has required here, you're going to have to show good cause. Now, I think Fletcher should have been able to come up with good cause without having to lie. He could have said that he was just brought on to this case a few days ago. That is generally considered good cause, especially if the court approved the transfer of counsel, because her old lawyer withdrew from the case so that Fletcher could come on and represent her. So if the court presumably approved that withdrawal and substitution, then he has good cause baked in to be able to delay this case a little bit more.
But Mr. Reed has made it abundantly clear that he has no desire...
Settle! Settle, 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 settle!
I do want to settle, Mr. Reed. You convinced me yesterday. I'm the victim here. I'm starved for affection. I'm driven into the arms of another man.
7!
Yeah, whatever. With the story you came up with, I don't think we can lose. I want to proceed.
Mrs. Cole, don't understand.
Mr. Reed, do we have a settlement?
No!
All right, that's good. An attorney has an obligation to provide all offers of settlement to his or her client. And in the first instance, Fletcher Reed tried to settle the case without talking to his client, which would be a violation of the model rules of professional conduct, which would be cause for disbarment if he went forward with that. So watch out for being disbarred. But ultimately, he conferred with his client, provided the terms of the settlement, and she rejected it. She has the ability, as the client, she's the one that's in charge of the litigation, and she can choose to reject that settlement and move forward. That's up to her.
You know why I pulled you over?
Depends on how long you were following me.
Why don't we just take it from there?
Don't talk to the cops.
Here goes. I sped. I followed too
Stop.
closely. I ran a stop
Stop
sign.
talking to the cops.
Some more. I failed to yield at a crosswalk. I changed lanes in the intersection. I changed lanes without signaling while running a red light and speeding.
Is that all?
No. I have unpaid parking tickets. Be gentle.
All right, let's talk about what Fletcher Reed should have done in this situation, with the understanding that he can't lie. just because you can't lie doesn't mean you have to tell the police everything. So what I would have recommended, and what Fletcher should have known if he was a better lawyer, is that you don't have to talk to the police. You almost always have the right to remain silent. That's, in fact, what the Miranda warning is all about. You have the right to remain silent. Now, the police can ask for your identification. They can ask for your driver's license and your registration without any real objection. But that doesn't mean that you have to talk to the police, nor do you have to answer their questions. So generally speaking, and there are of course exceptions to this, but Fletcher didn't need to tell the police everything that he had done. He could have just sat there silently and let the police draw their own conclusions. Now, many police officers will tell you that if you remain silent during a stop, that may give them probable cause or reasonable suspicion that something else is wrong and that they can do a more thorough search. But here, Fletcher doesn't appear to have any evidence of other wrongdoing except for those old parking tickets. It's not like he had a bunch of cocaine in the trunk of his car and he didn't want the police to search his car. So potentially the police could have responded to his silence with the assumption of reasonable suspicion of some other crime, but they wouldn't have found anything else, and they would have only been able to write him 1 or maybe 2 ticket infractions. So if Fletcher had been a better attorney, he just would have stayed silent, given the police his ID and registration, and taken whatever ticket the police gave him, instead of making his situation so much worse.
You scratched my car!
Where?
Right there!
Oh, there. That's already there.
You liar! You know what I'm gonna do about this?
What?
Nothing! Because if I take it to small claims court, it'll just drain 8 hours out of my life, and you probably won't show up. And if I finally got the judgment, you'd just stiff me anyway. So what I'm gonna do is piss and moan like an impotent jerk, and then bend over and take it up the tailpipe!
You've been here before, haven't you?
So Fletcher points out that while he would be correct in suing this tow yard for the damage that they have done to his car, it would be very time intensive, and even if he won, he might never see the money to compensate him for that damage. That's called being judgment proof, where even if someone gets a valid judgment against you, you have so few funds that you couldn't even pay that judgment, even if you got a court order. So that happens all the time, where sometimes the people that commit civil wrongs or do illegal acts are the ones that are least able to pay for the damages that they cause. So Fletcher finds himself on the other end of the spectrum when it comes to lawsuits, where he has a valid lawsuit, presumably, but he'll never see money as a result of it, which is, it's an issue.
Hello, Judge Stevens, hi! Fletcher Reed, I'm scheduled to be in your court in half an hour.
Oh, talking to the judge.
Badly need a continuance. Ill? Am I ill? That is the perfect question for you to ask. Greta, please lie to him for me.
Okay, I have never heard of any instance where a particular lawyer was able to call up the judge's chambers and get the judge, the actual judge, on the phone. That basically should never happen. There are times when you can call up chambers and eventually get the judge on the phone, but in almost all of those situations, you need opposing counsel present as well. For example, if you had a deposition where you thought the witness was behaving improperly, such that you had to shut the deposition down and the witness would have to be recalled, well, you could threaten and follow through with your threat to call the judge and report that behavior. You'd put the judge on speakerphone and talk about the situation that you're in so that you can hash it out right there and then, so you don't have to call the witness back to do another deposition and incur additional costs. But that's a situation where even with the judge present, you're going to have the other side there so that you have a communication between all of the parties, not just one party and the judge. These are called ex parte communications, the communications that take place outside of court. And I've never, ever heard of a time when an attorney could just pick up the phone and call the judge. That kind of ex parte communication would be very, very frowned upon and would be potentially grounds for sanctions because the other side doesn't know what's going on. So that really should never happen.
Mr. Reed, several years ago, a friend of mine had a burglar on her roof. A burglar. He fell through the kitchen skylight, landed on a cutting board on a butcher's knife, cutting his leg. The burglar sued my friend. He sued my friend, and because of guys like you, he won. My friend had to pay the burglar $6,000. Is that justice?
No. I'd have got him 10.
All right, here's the thing about that example about the burglar falling through the roof. That is a complete urban myth. I hate hearing that example. It never, ever existed. That fictitious example was created specifically by politicians in order to argue for something called tort reform. In other words, making it harder for plaintiffs to be able to sue individuals and entities for harms that may have befallen them. Now, you can agree with tort reform or you can disagree with tort reform, but the particular example of a burglar falling through a skylight into a kitchen and then suing the homeowner simply never happened. It is just a piece of fiction that was created for argument rather than legal precedent. So if you hear someone use that example, ask to see where that case came from, because I guarantee that is an urban myth and not a piece of judicial precedent. And on top of that, if that example ever did happen in the real world, there are all kinds of reasons why the homeowner would succeed. I don't want to get into the details of the difference between an invitee and a trespasser and the duty that one property owner owes to another, but suffice to say, there are a lot of reasons why a homeowner would be successful in defending a suit against a burglar who had fallen through a skylight. So just know that that particular example is completely fictitious and made up for the point of political argument and has no real basis in the law itself. All right, that was the first half of Liar Liar. Next week we'll get to the trial, including the question of whether the prenup and the marriage itself was void due to fraud. But now it's time to give the first half a grade for legal realism. There's a lot going for Liar Liar. You've got the real books that people use in practice. It was filmed at apparently a real law office because it was right across the street from my old law office. And you've got some of the dialogue that's pretty realistic. On the other hand, you've got completely insane things happening due to a curse that required him to say only the truth. You've got a lawyer who doesn't know when to shut up. All in all, I'm going to give Liar Liar a B+. Not a bad effort, but there's definitely room for improvement, and we'll see how you do next time in the second half. All right, do you agree with that B+? Leave your objections in the comments and let me know what you think I should review next. In the meantime, check out this playlist I put together that includes all of my prior reactions, including Suits, Better Call Saul, and tons more. So click on this playlist and I'll see you in court.